first case before us is General Electric Company versus Summit County Board of Revisions et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know as I will be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument if that applies. If it does apply, you can refer to them by initials like the child, or initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you, Your Honor. Counsel, may it please this honorable court. I'm Keith Petty with Jones Pyatt Law, and I represent Appellant General Electric. Before I give a summary of our argument, there is a bit of housekeeping. We are withdrawing assignment of error number 3, as we do not intend to get into an analysis of the weight of the evidence as presented at the BTA. Furthermore, we are narrowing our requested relief to remand the case to the BTA for further gathering of evidence and analysis of the facts. We are no longer requesting that this court adopt a specific value for this property. And that brings me to the key point of this argument. The BTA made a clear and unmistakable error in fact-finding as it relates to how the parties valued a portion of this property. This ultimately resulted in a decision that is not supported by the evidence, which is unreasonable and unlawful. The standard of review, I think we all agree, is RC 5717.04, and relevant cases to further explain that would be Tulo and a decision by this court, Amherst Marketplace Station. At issue is the value of the unimproved 45 acres of land adjacent and to the east of the main improved portion of this property. The BTA concluded that Mr. Barker, appellant's appraiser, failed to attribute value to the unimproved land east of the main site, while Mr. Sprout, appellee's appraiser, determined the unimproved land was worth $4 million or $100,000 per acre for 40 acres. As a result, the BTA found Mr. Barker's appraisal to be less credible and adopted the value of Mr. Sprout's appraisal. But the BTA made a very clear factual error in reaching this decision. Both parties attributed no value to the unimproved 45 acres east of the main site, and both parties attributed some value to the remaining 55 acres. Both parties agreed to this. Only Mr. Barker's appraisal was found to be less credible as a result of not valuing those 45 acres. This requires a remand for the BTA to sort this out. If the court would, if you want to follow along at page 7 of the BTA opinion, this is where we really see where they made their error. Starting with the first full paragraph. Here, both appraisers agreed that the land east of the buildings, approximately 40 acres, was unimproved. Barker and Sprout testified that the land has a steep slope, is densely wooded, and contains a tributary and pond. Each agreed that a potential buyer or user of this land would have to invest lots of money to make it usable. And I'll step back. I'm no longer quoting from the decision. So far, so good. We are in agreement. We are talking about the same part of the land. They call it 40 acres, and I think this is where they made a bit of a misunderstanding. We would agree that it's approximately 44, 45 acres. It's neither here nor there. The fact is we are all talking about that part of the property that slopes and is to the east. Then we move on to the decision in the next paragraph. Both appraisers captured this information in their narrative and during their land sales analysis. However, Barker failed to attribute any value to the 40 acres. He concluded that it was surplus, but he accorded it no value. Similarly, Sprout determined that the unimproved land was surplus. However, he gave it a value of $100,000 per acre. This is the same value that Barker used for the excess land at the front portion of the subject. So, it should become very clear that the BTA misunderstood which portions of this property both appraisers attributed no value to and which both appraisers attributed some value to. This is not a reweighing of the facts. This is a clear decision by the BTA that is not supported by the evidence, which is unreasonable and unlawful and should be remanded.
Counsel, it just seems like this is a new argument.
Your Honor, if you look at our reply brief, the argument isn't new. I would say that the briefing process has been instrumental here, and I think it did its job in terms of allowing us to clarify the facts that are at issue, because this was a somewhat confusing case. If you read the transcript, there
It
was...
was very confusing in regard to surplus land, whatever you call it.
Yes, Your Honor, and both appraisers carved up the property differently in terms of what they considered the main site, what they considered surplus, excess, and then what was not valued. But then, through the course of the briefing, the issue became clear, and then in a rereading of the BTA's analysis, it jumps off the page. And this is addressed not only the facts are in appellee's brief, but in our reply brief, we hone in on this.
Well, I know, because when I was reading your reply brief, I was like, wait, it seems like a new argument.
Well, we argued this in part, Your Honor, in our first brief. We talk about 22 acres that we knew that Mr. Sprout considered floodplain and he attributed no value to. But again, as we sussed out the record and further understood what was going on, it was actually the entire 45 acres that was attributed no value by Mr. Sprout. I'll add one other thought, that's really the crux of my argument. Appellee might argue that there was another basis that the BTA ruled in Mr. Sprout's favor for his value, and that's the sales comparison approach. I'm not going to touch on that because that would be asking you to reweigh the evidence. I would highlight, though, in the BTA decision at page 2, the court states at the bottom of the first paragraph, the remaining 40 acres east of the buildings are unimproved. This portion of the property is the central focus of this dispute. So this it's actually 45 acres. This 45 acres, it's not just a side issue. This is the big issue. There's also a sales comparison approach, but our request is to send it back, allow the BTA to more fully understand these facts, and then let the chips fall where they may.
Counsel, I was very confused when I was reading it, and I have not had an opportunity to go through the transcript yet. So hopefully it's a lot clearer in looking at the transcript and the reports of the appraisers. But it seems like your appraiser was giving an overall value with the usability of the land, period, as a complete entity, so to speak.
Your Honor, that's an argument that I made, and it was a bit of a pushback against the nominal value theory that the BTA introduced in its decision. It's possibly too cute to say that, hey, this is one parcel, it has one value. However, as the appraisal breaks it down, there are component parts within the larger parcel that has some value attributed to it and others that do not. But overall, and that was an attempt to distinguish the cases that the BTA cited. Most of those cases that talk about land should not have a nominal value talk about the entire parcel, that the taxpayer requests that the entire parcel should have no or nominal value. That's not what we're doing here, right? I mean, so we've attributed a value and different values to different portions as reflected in the appraisal report. And if I have a little bit of time, so it might be helpful if I direct the court's attention to the pages where some of these, where these 45 acres are discussed. So starting with Mr. Barker, he mentioned that 45 acres has limited utility, and that's at the Barker appraisal at page 48. He mentions again at the transcript at pages 51 and 52 that 45 acres isn't really usable. Then we go back to where it's mentioned by Mr. Sprout. 44 to 45 acres east of the buildings with no or nominal value. That's on page 4 of Pelly's brief. Mr. Sprout did not determine a value as the remaining 45 acres of the 99-acre site. That's again at appellate's brief at 6, but then they refer to the transcript at page 82. They are not accounted for. It's going to be a de minimis value, in my opinion, based on the information that was available to me. And again, appellate's brief at page 15, both appraisers did not assign any value to the land addition. And, Your Honors, so it appears to me that the BTA was confused by this. They weren't sure which parcels Mr. Sprout was valuing and not. And as a result, it's a decision that's not supported by the evidence, and we respectfully request that it be remanded.
So your position, just to clarify, is that we have two expert appraisers. They valued the property differently, but the BTA's decision was deciding which one was more credible was based on a faulty premise, that something that doesn't exist in the text.
In part, Your Honor, yes, that's correct. So on that issue of the 45 acres, Mr. Barker was found to be less credible in large part because of that.
Because of the nominal value assessed, when really both appraisers did nominal values.
Exactly, Your Honor. Any other questions? Okay, that completes my case. Thank you very much. And if I have remaining time, if I could reserve that, is that? Thank you.
May it please the court, good morning. I am David C., counsel for Twinsburg City School District Board of Education. So, I apologize on behalf of both counsel for bringing you a lot of property tax valuation. This is not the normal cases that you typically see, so we're inundating you with appraisals and the world that Keith and I live in. But the standard of review in this type of case is whether the decision of the Board of Tax Appeals is reasonable and lawful. The case law provides, especially where you have dueling appraisers, that this court does not serve as a super BTA. There's a lot of deference given to the decision of the BTA. So we have a property in Twinsburg. Well, General Electric is the record owner. Baker Hughes is operating an industrial warehouse R&D facility at the property. It's 99 acres of land, 2 appraisers. Mr. Sprout determined the main site was 15 acres and assigned 40 additional acres as additional land that had to be taken into account in the valuation. Mr. Barker assigned 34 acres as the primary site, largely expanding the site and limiting the amount of what we would call surplus land to 20 acres. Now, Mr. Petty today is advising you that they no longer want to pursue assignments of error number 3. So that leaves assignment of error number 1 and assignment of error number 2. And the Supreme Court has held that designating assignments of error is imperative in a property tax appeal, and is what this court is and what they are bound by. And so assignment of error number 1 is the BTA's decision to increase the value of the subject property for January 1, 2021 to $9.9 million. It's contrary to law and unsupported by evidence because the BTA failed to give adequate weight to Gary Barker's appraisal. So that's essentially saying that the Barker appraisal was a better appraisal than the Sprout appraisal. That's your typical, the BTA erred by ruling in favor of Sprout over Barker. Assignment of error number 2 is the BTA's decision is contrary to the law and unsupported by evidence because the BTA relied upon cases that simply do not apply to the subject property and that were not raised by the arguments at hearing or in the briefs. So that goes to some cases that appellants, or the BTA use that appellant may disagree with. I do not see an assignment of error for the argument that Mr. Petty is making, has made to you in his argument this morning.
Aren't the cases he cites about assigning nominal value to property?
Correct.
And we have two appraisers who did that, but only one of the, then that being acknowledged in only one appraiser is being acknowledged as assigning nominal value within the opinion from the BTA.
I don't read it that way. I think the BTA's decision looked at the handling of the surplus land by both appraisers, and they're referencing the additional land.
But the BTA found one of those appraisals to be less credible because of the
Correct.
nominal value, although both appraisers did that.
Correct. And the reason being that in Ohio law, you typically do not, if both appraisers are assigning nominal value to the 44 acres to the east, the BTA was pointing out that we typically do not assign zero value to property. That was the purpose of those citations. What I don't see is an assignment of error to what Mr. Petty is arguing in his argument that the BTA was mistaken. I think he was saying that they were mistaken or they erred in their discussion. And even if there was an assignment of error, then the issue is, does it really matter? The BTA was weighing two appraisals, and considering the credibility of the two appraisals, looking at both the sales approach, and then Mr. Barker only had one approach, and weighing the evidence between the two appraisals. So, Mr. Barker, and we point this out in both of our briefs, one of the problems with Mr. Barker's appraisal is that by expanding this main site to 34 acres, limits the consideration of surplus land to 20 acres. And then when he does a sales comparison approach to value, he makes an adjustment because of many of his comparables have dissimilar land to building ratios. And we point out that by using a 34-acre site, he had a much greater land size than you would need to support the building. And by doing that and limiting the surplus land to 20 acres, the way he accounted for that in his adjustments to the sales was to provide a minimal or 10% adjustment for the extra land. And we showed through Mr. Sprout's testimony and the briefing that Mr. Barker was significantly understating the contribution of that additional land.
Council, let me take you to page 7 as appellant's counsel did of the BTA decision, where it says that Barker failed to attribute any value to the 40 acres. He concluded it was surplus but accorded it no value. Similarly, Sprout determined that the unimproved land was surplus, however, he gave it a value of $100,000 an acre. What, is that correct? Or I'm just not sure what anybody's trying to say anymore.
I see your confusion. I think the BTA is looking at Mr. Sprout was assigning $100,000 per acre to the 40 acres beyond the 15-acre site.
But is that statement supported by the evidence that he made that evaluation on that acreage?
It's in the record. Yes, it's in the.
So that's a correct statement of what the appraisal did.
That is a correct statement. Mr. Sprout valued the primary site at 15 acres, and then attributed 40 acres at $100,000 an acre. Okay, he did not take into account the land to the east. And Mr. Barker valued 34 acres, and then only assigned 20 acres as surplus land. Both appraisers were valuing, you add it up together, 15 and 40, 34, 35, and 20 equals 55 acres. Both appraisers were valuing 55 acres, and neither appraiser determined that the land to the east, that actually the 44 acres, had any value.
They didn't appraise the land to the east?
Neither of them assigned any, they appraised it.
Okay, but they didn't assign any value.
Now, now the difference is, upon questioning it by me and by appellant, again, you're looking at a whole site. Mr. Sprout pointed out that, again, we're valuing a 9,900 acre site, that if you were looking at it in totality, of course, the land to the east that's on a slope that has terrain issues does have value if you were looking at it in the totality. But in terms of developable, buildable sites, both appraisers looked at the 55 acres. So our comment goes to that the appellant did not assign an heir to this new argument I'm hearing today for me to address. Further, even though it's argument, it still gets to you still get down to the issue of two appraisers, a battle of appraisers, and a decision by the Board of Tax Appeals choosing one appraiser over another. And the established case law where courts in Ohio like this and the Supreme Court do not serve as a super BTA. Thank you.
You have a little over 4 minutes.
Yes, sir. So, Judge Carr, I think in response to your question about whether the BTA's language on page 7, whether it was supported by the evidence, I think even Appellee was confused for a moment there, because it's quite clear from the record, and there's no dispute between the parties on this, that Mr. Sprout did indeed value a 40-acre portion of the land. He called that surplus land, and he valued it $100,000 per acre. But that land is a part, so if we can look at the property like this, here's the 55 acres that both valued. Here's the 45 acres that neither valued, and it kind of lines up like this. The 40 acres that Mr. Sprout valued was within this 55. So, and we agree on these facts. That's not in dispute. And so I would just reiterate once again that this is not an issue where we're attempting to relitigate the facts in this case. To Appellee's concern that our assignments of error weren't clear, I believe the arguments I'm making about this, about the inconsistency between the record and the BTA's decision, falls squarely under both assignments of error 1 and 2. And as mentioned, yes, it has taken a little bit. The briefing process has clarified some of these issues and facts, and this is what we have revealed today. And I think it's unmistakable from the record. And that's all I have. Pending further questions.
Thank you. The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy on the day it's released, and the opinions are posted on the Ohio Supreme Court website. Thank you both for your presentation.